The Murder Shelf Book Club contains disturbing content related to real-life crimes. Listener discretion is advised.
Are you looking for a movie podcast with deep dives, interviews, and thoughtful film analysis?
We ain't got none of that. What do we got?
You want to hold the bucket?
Right, I'll hold the bucket, sit in the cup chair.
There with I will never blink. I'll just be there holding the bucket.
I will never blink on her drapes, most likely. You look like a drape jizzer. R.I.P. that sweet, sweet pussy. It is known that Jessica Tandy had the sweetest pussy in Hollywood.
If you don't know, Google it. Don't Google Jessica Tandy's pussy, you guys. Don't do it. Don't do it. Doom Generation.
Available anywhere you find podcasts.
I backed out and stood at the top of the stairs facing the upper level. I tried to imagine the eardrum-piercing howls of the alarm siren, knowing that the smoke was hanging down from the ceiling, smoke filling the house. Coming up those stairs and then turning to the right to go into the living room to get a portable telephone, instead of turning left to get a helpless and perhaps wailing infant. That was William Wise's inexplicable decision. From 16 Minutes was the death of baby Matthew an accident or murder by Diane Marger Moore. Welcome to the Murder Shelf Book Club podcast. I am your host, Jill. This is episode 119, part 2. Justice delayed is justice denied. On 16 Minutes was the death of baby Matthew an accident or murder by Diane Marger Moore. A quickie shout out to our new Patreon murder bookies, Hoffman Jass and CM Keys. I see you as you hear me. Murder bookies, buckle up. This episode has more twists and turns than a roller coaster. And please listen to part 1 before this episode, part 2, because you're really not going to understand all that's going on. Recap. Charged with homicide and felony arson, the case against William Wise has languished for 2 years until new arson prosecutor, our author, Diane Marger Moore, took up the case with the murder of Matthew Dean Wise, an 8-week-old newborn who perished in his crib at home. With their fire alarm sounding, alerting them to a fire, it was not immediately turned off, because then you'd be able to hear Matthew screaming, right? And neither parent retrieved the baby from the nursery. Father William Wise blamed the baby monitor for starting the fire. However, both the fire department and insurance company ruled the fire as deliberately set. Rushing to get up to speed with trial just 3 months away, Prosecutor Diane Marger Moore interviewed witnesses and experts and analyzed the statements by William and Michelle Wise, Matthew's mother. Then Diane discovered that Allstate Insurance had spent a significant amount of money to create a test burn room, providing a real-time, real-life comparison of what a nursery should look like after a 16-minute accidental fire versus the other deliberate immolation of baby Matthew's room and the baby himself. The big but. The test burn room was not 100% identical to the nursery. It was similar, a comparison, but not a replica. In the Wise house, the studs were 2x2, while the burn room featured 2x4 studs. The Wise house had an old layer of carpet with a new layer on top, whereas the burn room contained 2 layers of new carpet. The baby monitor had been located near the crib in the test burn room, but it had been positioned underneath the crib in the Wise home. The defense would pound upon these minor discrepancies as they would try to keep the test burn video out of the trial entirely, and a major battle loomed. And Diane knew this could evoke sympathy from the jurors who couldn't help visualizing a small baby in that crib burning. Yet, Diane's biggest concern was that the test room team had placed a plastic bottle of alcohol on the changing table, with this found partially melted on the floor of the test burn room, even after the flashover. No alcohol bottle was actually found in the Wise nursery. Fun fact, rubbing alcohol is often used to keep a newborn's umbilical cord clean until it falls off. And both Wise and Michelle had stated that they used rubbing alcohol, but were certain that it was on the dresser away from where alcohol was found in the carpet, and perhaps the bottle was even in the bathroom. So therefore, the location of the alcohol bottle in the test burn room video could confuse the jurors, ultimately undermining the lab results. And was this even admissible as evidence? Well, Diane needed to conduct some research to find out. And the white elephant in the room, Diane's experts disagreed. There were discrepancies over the burn patterns and type of accelerants, hydrocarbons versus isopropyl alcohol, used in the fire. Cause detecting inspector Stephen Shand was adamant that David Lepper, the arson investigator for the Indianapolis Fire Department, was wrong. Quote, "There is a great deal of burning at the floor level and in a wide area, far beyond the space that Lepper identifies as the area of origin. Alcohol would have evaporated too quickly to have covered such a large area, and the marking and patterns are more representative of a hydrocarbon fuel." End quote. Well, was there any way to reconcile the findings of these two men? Steve Shand opined, no, there wasn't, although they both agreed that the fire was intentionally set. Diane asked, why were there no hydrocarbons in the carpet sample? Shand explained, quote, "Most of the time, the fire burns all traces of the accelerant like it did here. I would be more surprised if there was any accelerant present after that fire." End quote. He reaffirmed that the accelerant was a hydrocarbon. Grateful for Shand and Barker and Herbert's analytical lab's engineer, Jim Finneran's input, Diane and Detective Wilson left, heading back, her face aching from the need to smile and remain diplomatic. Wilson summed up what they'd learned, quote, "Not going to be easy," end quote. Okay, so I want to make a point about this discrepancy between the hydrocarbons and the isopropyl alcohol. All right, at this time, the CSI of determining what or wasn't an accelerant was far more difficult than today, 40 years later. And I want to introduce an expert, biochemist, Dr. Dan McCracken, who can explain how the science has changed. Dan, thank you so much for joining me.
Thank you for having me. So I understand that for this particular case, there's a discrepancy between whether it was a hydrocarbon or an alcohol involved in this fire.
Yes, exactly.
So it was these GCMS, gas chromatography coupled with mass spectrometry in order to determine which was which, correct?
Exactly.
So now, modern day, today, when we look at GCMS, we can very easily tell the difference between an alcohol and a hydrocarbon because they come off as different, basically, species that we see in the chromatograms and their ionization versus charge, which is what mass spec looks at. However, when we start looking back at 40 years ago in the 1990s, we need to keep in mind that mass spectrometry instruments today, they exist on a bench top, a countertop, a fairly intact small instrument. But in the 90s, they were the size of rooms.
Gotcha.
So that long ago, you're looking at very specialized equipment that takes people that are extremely experienced to run and deal with. And so it's very easy to imagine that when they were looking at this charge versus mass dispersion of the mass spectrometry, it could have gotten convoluted back then. The science wasn't where it is today, basically.
So the instruments have improved. And you said to me, too, that there's literally a molecule difference between.
Yeah. So when you look at the difference between an alcohol and a hydrocarbon, the difference is that one of those carbons is replaced with an oxygen when you go from a hydrocarbon to an alcohol.
So I can see why it was tricky then 40 years ago, trying to find that difference in the sample in a carpet that's been burned.
Yeah. For example, when you're looking at the mass difference there, the difference between a carbon and an oxygen are extremely low. So analyzing it by mass spec in this basically room-sized instrument isn't going to have the kind of specificity that we would have today.
Perfect. Thank you so much for doing this. I could never have explained that. I defer to your scientific mind, and thank you so much for coming on the show.
Oh, you're welcome. Thank you for having me.
Well, thank you, Dr. McCracken. I understand it a little better, and it's always better to hear from the professionals. So murder bookies, in case you were ever called to be on a jury, if it comes up today, the hydrocarbons and the rubbing alcohol, you know that we can scientifically determine one from the other and that this uncertainty no longer exists. Awesome. So on Sunday, Diane called the lawyer representing Bill and Michelle Wise in their lawsuit against Fisher-Price. He was a nice man, especially considering that he was being bothered at home on his weekend off. He offered her all of the Fisher-Price 1510 model baby monitor sets that she needed, all manufactured between 1990 and 1993. This was excellent news, as a courier would deliver them right to her office. And since her budget was non-existent, any help like this was appreciated. She would definitely keep some for the trial and send a few over to Finneran at Barker and Herbert. Diane and family gathered for dinner with her mother and her husband, Bruce, who was seriously interested in the Wise case that was attracting a lot of publicity. Bruce was reading every article and watching every newscast. Diane explained that she needed to prove 3 things: that the fire was not accidental, that the baby monitor did not cause it, and that the fire was intentionally set by William Wise. Bruce listened carefully and mentioned that if he were on the jury, he would want to know how Wise started the fire. Without that information, Bruce felt he would have to give Wise the benefit of the doubt. Quote, "If they can't say how he did it, it must have been an accident." End quote. Oh boy. If Diane could prove that the baby monitor wasn't at fault, would that be enough? Well, Bruce said it was a good start, but he wondered why a planner like Wise would highlight the monitor unless he suspected it could catch fire. Well, Diane said she suspected that Wise thought Fisher-Price had deep pockets. Well, after a pleasant dinner of chicken Kiev, vegetables, and homemade bread, the Moores began packing up. Bruce then mentioned to Diane that when he and her mother were still living in Cairo, Indiana, he recalled a program about a baby monitor that caught fire. Reeling, Diane's mind raced. They had moved only months prior to the fire. Holy shit, had that show aired in Indianapolis? Well, she had to find out. Diane first consulted the friendly Fisher-Price attorney, who confirmed that there were no fire-related lawsuits against them related to the 1510 Deluxe model. She then checked the Consumer Product Safety Council for recalls, finding nothing. However, after digging further, she learned about a Jerry 602 baby monitor linked to a child's death and asked Jim Finneran to do some digging. Meanwhile, she went and bought a Jerry 602 at her consignment shop. This model had a receiver and transmitter with normal-looking standard cords and no step-down transformer, and she needed Jim Finneran to clarify exactly how the Jerry 602 differed from the Wise unit. Now they were just weeks from trial, with the defense bombarding them with motions to exclude various evidence, including Michelle's abortion, arguments about aborting Matthew, suppressing Wise's statements to police, plus the burn room and its video, arguing they were all too prejudicial. The judge ruled that Michelle's first abortion was out, but the attempt to push her into aborting Matthew was admissible, as was the test burn room. After settling these motions, the defense filed more, while the prosecution deposed who they thought might be key defense witnesses, like Michelle Wise and other possible defense experts. One expert had previously made a vague claim that baby monitors could cause fires, as well as 9-volt batteries. Well, meanwhile, Diane managed her other arson cases while juggling all these baby monitor issues. Detective Leslie Van Buskirk and Diane returned back to Barker and Herbert Labs in that big blue monster car that she drove. Shand and Finneran met them. Quickly explaining the Jerry 602, Finneran held up a dismantled version, stating that it was the, quote, transmitter that poses the safety hazard on this baby monitor, end quote. He explained that there was no step-down transformer for the Jerry. Instead, the cord allows the full 120 volts to travel down the wires into the transmitter, which just does not require that much power to operate. The transformer is integrated into the transmitter unit itself, unlike the Fisher-Price unit, which steps down the current at the outlet. The Jerry 602 steps it down inside the unit. Now, this means that if there is a short in the wiring before the current is stepped down, it will behave like a short in the outlet. So in other words, this can potentially lead to a fire. While the Fisher-Price model 1510 Deluxe Baby Monitor cannot start a fire in its transmitter unit, the Jerry 602 Deluxe Baby Monitor definitely can. Diane understood the implications, and I hope that you do too. Now it was crucial for Judge Barney to understand this as well, especially since there were still Jerry 602 models available on the market. Let that sink in. Switching gears abruptly, Diane asked what the defense expert meant about a 9-volt battery causing a fire. Jim Finneran chuckled, asking, "Were none of you Boy Scouts?" He explained that in survival training, you're taught to carry fine steel wool and a 9-volt battery. When the steel wool touches both terminals, it heats up, igniting a fire. I do vaguely remember that from my Girl Scout days. So Steve Shand produced a Brillo pad and a 9-volt battery and created a flame. But Shand advised, quote, unless Wise had very fine steel wool in the nursery, the 9-volt battery did not cause the fire, end quote. Oh, and by the way, how is shipping the burn room arrangements coming? Diane only groaned. It was coming along, but it was a logistical nightmare. Now the trial was just a week away. Diane struggled to find a media outlet that had covered the death of a child linked to a Jerry 602 baby monitor. Although she believed in Wise's guilt, she wanted to remove any reasonable doubt. After a million calls, she finally reached a young man from Nightline. Oh, I remember watching this program, Eastern Standard Time at 11:30. It would be 12:30 p.m. in Indianapolis. And the Nightline representative confirmed that they had aired a segment about a Jerry baby monitor that had killed a little boy. William Wise had finished working at midnight, and he and Michelle would watch TV together, making it possible for him to have seen this episode. Bingo. This had aired after the Wises' marriage, during the time Michelle was pregnant with Matthew. Diane thought, quote, a plan is born. If there was any remaining doubt, This squashed it. William Wise killed baby Matthew. It didn't matter that I couldn't prove Wise had seen the program, but I knew, end quote. And as usual, Detective Van Buskirk cursed her approval of Diane's detective work. Now, I found this next part of the book compelling, and I wanted to share it. Diane reflects the different expectations for male and female attorneys during a 2-week trial. Men can wear the same suit daily, but women must adhere to a stricter dress code. Nothing flashy, conservative dresses or skirt suits, pumps, appropriate jewelry, pantyhose, and subtle makeup. Wearing the same outfit over those 2 weeks was a huge faux pas, and jurors have commented on this. Failing to meet their expectations could hurt a woman's credibility, potentially freeing a guilty man. Now, has this changed, murder bookies? Let me know what you think. Email me at jill@murdershelfbookclub.com. And by the way, Diane also told her daughter, quote, "The man who created pantyhose was a sadistic psychopath," end quote. This, yes. All right, the trial began, and Diane Marger Moore stood confidently in the courtroom with 14 perfectly chosen outfits in her home closet. Feeling nervous at first, she was now in court, which was truly her natural habitat. Jury selection is a crucial process, aiming to ensure the jury's impartiality. This case was predominantly circumstantial evidence, which is just as significant and important as direct evidence, which is like an eyewitness account. Unfortunately, TV shows and mystery novels have tarnished the reputation of circumstantial evidence. But with decades of experience, Diane understood that some jurors struggle to accept circumstantial evidence as valid. As a result, she often excludes engineers, mathematicians, and school teachers from the jury pool, as they often feel that every detail must be proven with a confession, eyewitness testimony, or DNA evidence. Once during voir dire, an engineer had told Diane that unless he personally witnessed it snowing, or someone swore to him that it had snowed, he would believe the snow could have been brought in by truck and dumped outside. So, sorry engineers, you're not getting on Diane's jury. And AJ, I am absolutely thinking of you. Yes, you, AJ. Oh my God. Diane gasped as she spotted today's newspaper. The front page featured bold headlines on the Wise case, photos of the burnt house, and in the third paragraph, focus on Ray Ann Simons, mentioning that William Wise was a suspect in her murder. Talk about tainting the jury pool. Well, Diane and Van Buskirk stood on baby Matthew's side in court, joined by a few of her supportive colleagues. William Wise was flanked by Michelle, his family, and his in-laws. As the judge took his seat, defense attorney Jim Voiles sashayed in, flourishing this newspaper, asking, quote, "Have you seen this?" end quote. As Judge Barney responded, "You're a little late, Mr. Voiles. Please be seated," end quote. The judge reassured Voiles that they had more than enough jurors, considering the case's notoriety. Voiles then demanded that the prosecutor be sanctioned and asked for a mistrial. Well, Diane couldn't help chuckle to herself at the drama, thinking, quote, "When both the law and the facts are against you, attack your opponent," end quote. The judge remarked that the only source cited in the article was a defense spokesman. But unfortunately, hopefulness turned into hopelessness as 30 out of 30 potential jurors admitted to reading about and discussing the article and the Simons case. There would be no trial today. A new hearing was set to determine a new trial date. Oh my God, do you believe it? Because of a newspaper story, a rare mistrial. As Voiles left the courtroom with his client, he winked at Diane Marger Moore and Leslie Van Buskirk. Then, reporter George McLaren approached Diane, expecting her to be excited about the article. Instead, she dragged his sorry ass into a stairwell. Quote, "Don't you know the jury cannot know about Rayanne Simons? Even an idiot would know that. And you put the article on the front page the first day of jury selection? You are responsible for the delay of justice for an 8-week-old infant. Justice delayed is justice denied." End quote. Face burning, Diane went home, cooked, and spent badly needed time with her family. Months passed with William Wise a free man. One day, arriving at her desk, Diane found an envelope from the Indiana Supreme Court Disciplinary Commission. A complaint had been filed against her, claiming she threatened William Wise with jail time. The complaint feared retribution if his or her identity was revealed, and she had blah, 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 time to respond, blah, blah, blah. Well, respond Diane did, on Marion County Prosecutor's Office letterhead, writing, as the deputy prosecutor, that she intended to prosecute Mr. Wise, requesting a life sentence in prison, not jail. His wife, Michelle, remained a possible suspect, and she asserted that the complaint was false, knowing that the commission would share her response with the complainant, hoping that they enjoyed her response. I truly admire this woman. Finally, they were in court as Judge Barney set the trial date for July 31st, 1996. He stated that no delays would be tolerated. Diane decided to use both Steve Shand and David Lepper at the trial, blending their observations in the hope that the jury would understand and reach the right verdict. Van Buskirk then called with some news. The pathologist who had performed baby Matthew's autopsy had left the state. Well, Diane considered him a lousy witness, replacing him with the best forensic pathologist that they had, the opinionated John Pless, who had a great deal of documentation to review before the trial. Reviewing William Wise's personnel file. So he had been fully trained as a firefighter in Ocala, Florida, starting in September 1985, but was fired on November 7, 1986. After developing seizures, Wise had been warned by his doctor not to drive again, and despite this, he lied, saying he was fit to return to work. 9 months later, Wise had a seizure on a rescue call, which led to the diagnosis of epilepsy. Anticipating termination, Wise filed for unemployment despite being fired for cause, his lying, and then later submitted a workers' compensation claim, falsely claiming he was overcome by heat and gas fumes. Ultimately, his deception was uncovered, and the conclusion stated, quote, "Mr. Wise consistently lied about his health, engaged in cover-up schemes, and refused to cooperate with the county investigation." End quote. He was then fired permanently. Oh, and he had lied about this job in his deposition as well. Jean Wise's deposition about her son was revealing. As a child, William Wise was home alone when a non-accidental fire broke out in the pantry. Van Buskirk discovered another report from March 1980 when Wise, at age 14, stole a fire truck with a 13-year-old friend to run away and see his father in Florida. They crashed it a few miles from the firehouse. Balgo Township Fire Department Lieutenant John Walker noted that Wise, lying dramatically across the front seat of the fire truck, crying after bumping his head, corrected the lieutenant when he called him by his brother's name, declaring angrily, Bill." He admitted to having the lights and sirens on when they crashed, with his friend insisting it was all Wise's idea. He wasn't sure if this plan would work and had tried to back out, but Wise insisted. After throwing a brick through the firehouse window, they stole 2 helmets and the truck. Jean Wise noted that at the time her son wanted to be a paramedic and was enthusiastic and impatient. Both boys were arrested, and Jean permitted Bill to speak with the officers, where he took credit for the whole debacle, and then admitted to making 20 false fire calls to the Boggle Fire Department the previous year. He likes watching fire trucks in action, huh? Wise was suspected of an arson fire at his neighbor's house, though there wasn't enough evidence to prove it. Van Buskirk now knew that William Wise was, quote, definitely a firebug, end quote. Unfortunately, these suspicions of the juvenile Wise and his record were inadmissible at trial, being far too prejudicial. But this new information revealed that Wise was a manipulative planner who lured others into his moronic escapades. He often played the role of real fireman, never considering the consequences. Also uncovered was an incident where teenage Wise shot himself with a shotgun and then falsely blamed the boyfriend of a girl he liked. Well, the story fell apart, and the police later discovered the shotgun in Wise's garage. So who could believe this guy had no criminal record? I mean, he's covered his tracks well. Now Diane met with pathologist John Pless at the medical school where he was a faculty member. Pless, thin and a lifelong runner with white hair, informed her that Matthew Wise had died from carbon monoxide poisoning. The realization struck her hard. He had been alive while the fire was burning. Oh, God. Given that the fire only lasted 16 minutes, how long did it take to cremate a human body? Pless explained that the human body is mostly water, making it slow to burn. He'd have an exact number at the trial. And then the floor fell out of the room. Pless concluded, quote, there is no way the injuries to this body were inflicted in a fire of 16 minutes duration, unless the fire was accelerated on the body. End quote. Diane blanched, never suspecting this. Wise had poured accelerant on his son? Pless was certain of it, showing Diane one of the hideous photographs where the baby was unrecognizable. He pointed to a piece of what had been the diaper that was left in the area of Matthew's genitalia. All right, this is really rough, so brace yourself or maybe skip a minute or two ahead. Quote, do you see the infant's head has been burned away, along with most of his abdomen, all his digits, and most of his extremities? His internal organs were essentially cooked away, and yet his penis and scrotum were still pink, identifiable, and intact. The only explanation for this is that these areas were protected. End quote. Just bear with me. The liquid accelerant was poured on the baby, with the diaper soaking up some of it. Accelerant fumes burn, while the liquid in the diaper protected the skin underneath when the child was set on fire. Diane was rendered speechless. She asked her next question deliberately. If alcohol had been poured directly on the baby, would that have caused the body to burn to the extent shown in the photos? Pless wasn't sure. He'd never researched alcohol as an accelerant. However, he had testified about the effects of fire on the body, and this horrible truth the pathologist knew. Matthew had been alive while on fire before the carbon monoxide poisoned him to death. Dr. Pless, with impeccable credentials, who had not been deposed by the defense, would be the prosecution's most important witness. Whew. The test burn room was set up in a nearby parking lot in downtown Indianapolis, cordoned off with yellow evidence tape. Judge Barney was convinced to allow the jury to walk through the structure during the trial. Coming into the courthouse, Diane saw Wise and Michelle holding hands, hoping to attract the attention of the jurors or the media, while Diane and Van Buskirk felt nauseous. Diane writes, quote, "Trials are often more about perception than facts, and perceptions can be manipulated," end quote. She planned to ask the court to prevent Wise from having any contact with the jury, verbal or nonverbal. Jurors were quickly chosen, reflecting the diversity of Indianapolis with an equal number of men and women. Diane delivered her opening statement about the tragic death of an 8-week-old baby at the hands of his father. Defense attorney Voiles argued passionately for William Wise's innocence and condemned the prosecution's actions against a grieving family. The first witness was Officer Keith Williams, testifying about finding Wise in the open doorway of his home. 2 firefighters who extinguished the fire in 3 seconds of fog spray extinguished the fire by 5:16 a.m. And it had taken time to find baby Matthew due to the extreme amount of black charred debris. The newspaper delivery woman confirmed that there was no fire before 5 a.m. Michelle's co-worker spoke about the debate over whether to abort or keep baby Matthew. Diane observes that, quote, "Presenting a circumstantial case to a jury is like building a house. Every piece of information, each brick, must be stacked piece by piece to create the foundation of a conviction. After, all the evidence is solidified with the mortar of the closing argument," end quote. The burn room video was presented as evidence, stressing that it showed a similar room, not a replica. It was paused at the 16-minute mark so the jury could compare damage from the accidental fire with the photos of the devastating crime scene. The video then continued for another 20 minutes, showcasing flashover, which even then did not match the extensive damage done to the Wise nursery. Jurors then exited, going out to walk through the test burn room, silent and solemn. Returning to the courtroom, they heard what William Wise had told detectives and all state investigators during his depositions, some of which were redacted for trial to omit that which was inadmissible. Both the complete and redacted transcripts were admitted as exhibits. If there was a conviction and an appeal, a higher court would assess whether Judge Barney had made any errors using the complete transcripts. Crime scene technicians reported finding alcohol in the carpet, and Steve Shand confirmed that the fire was intentionally set. Lepper testified and was cross-examined by Voiles for 3 days, holding up well. When Voiles asked about the cause, Lepper said it was arson. And since no one questioned Shand about the alcohol, the conflict of their opinions was muted.
Oh, good.
Diane's motion about the Jerry 602 baby monitor had been successful, so the jury would not hear about that fire. Only Fisher-Price 1510 baby monitor information would be accessible. Jim Fennerin explained how the step-down transformer prevented the monitor from receiving enough power to start a fire. And the final prosecution witness was Dr. John Pless. As horrifying as the photographs were, Diane had jurors look at the final photos of Matthew at birth and at autopsy. Dr. Pless testified that someone had poured an accelerant directly onto the helpless 8-week-old infant, and then the infant was set on fire, as 2 jurors broke down in tears. Diane asked, quote, "Would alcohol have caused baby Matthew's body to have been burnt to the extent that you observed it, doctor?" He replied, "Yes, there was no other explanation," end quote. And the prosecution rested with over 100 pieces of evidence, including photos, transcripts, statements, debris from the scene, and the police radio hidden in the Wise's bedroom. Now it was the defense's turn. Voiles called Michelle Wise, Wise's mother Jean, and other friends and family to testify on the behalf of William Wise. Michelle described her frantic actions of searching for her shoes and calling 911, holding a tissue but not crying on the stand. A neighbor noted that Wise called 911 and rushed back to save the baby. Two expert witnesses explained that the extensive damage could have resulted from accidental causes involving the foam mattress. Then, a video was shown to the jury of a child's bedroom with blankets and stuffed animals, where a fire quickly escalated to flashover as the jury's eyes went wide. Having never seen this video before, Diane asked the expert for clarification. Quote, "Is there more to the recording that you did not show the jury?" He responded, "Nothing relevant to my testimony," end quote. The coached response. And then the jury was removed as Diane got to view the whole video. Now with the jury returned, Diane played this entire recording, and it was clear what the defense had shown was misleading. This fire had burned for over 15 minutes before reaching flashover. Towards the end, the jury now saw that even after everything was in flames, had caught fire, furniture was identifiable and standing, unlike the ash that remained in the Wise nursery. A second defense witness presented a video showing steel wool catching fire. Diane, knowing that two jurors were former Boy Scouts, cross-examined by pulling out steel wool and a 9-volt battery. She asked if he was suggesting that the Wise nursery contained steel wool. Well, no, he wasn't. But he emphasized that a 9-volt battery could start a fire. Diane handed him the steel wool and battery for a demonstration, and he reluctantly admitted that this type of steel wool would not ignite. Oh, so it was only the finer grade steel wool under perfect conditions that would burn. And he had to agree, and the defense rested. Closing statements began with Diane, and then Voiles, who oddly turned to speak directly to two African-American female jurors, ignoring the others. Was Voiles trying to compel either of them to hang the jury? This tactic was certainly a first. He also hinted that Michelle may have started the fire. And then the judge instructed the jury to wait for the evidence before beginning their deliberations. Diane and Leslie Van Buskirk felt the fatigue set in as the court reporters spread the trial exhibits across a large table. The judge instructed Diane and Voiles to review them before the bailiff delivered everything to the jury. All set, Diane was starving and left her pager and phone number with the court staff before heading out for a late Friday lunch with Van Buskirk. As the food arrived, her pager went off. The jury had a question. Hurrying back, she and Voiles and the judge met. Question written down. The usual procedure involved reading the jury question to the lawyers, who would then agree on a response, which was honestly usually, quote, "The court cannot respond to your questions. Please continue your deliberations," or "Please reread the court instructions to you," end quote. The attorney and the judges read, quote, "Judge Barney, are we supposed to have a transcript that talks about William Wise being a suspect in the murder of Ray Ann Simons and her unborn twins?" End quote. The air went out of the room with all stunned. What the hell? No one could believe it. They had failed to remove the unredacted transcript from the pile of exhibits, and a juror had read it. Voiles immediately wanted a mistrial. And I get it. Fairness in any trial is essential. This meant that the case would have to be retried. Struggling to breathe, Diane noted that only one juror may have read the transcript, and they did have two alternates, so the judge agreed to poll the jury. And it quickly became clear that several had read the transcript and were aware of Ray Ann Simons' murder. A mistrial was declared, and I felt my heart sink. One juror even asked if Mr. Wise had been charged in the young woman's death, which just brought me to tears. Diane urged the court to take Wise into custody, citing his potential danger and flight risk. Nevertheless, Judge Barney released him, upholding the presumption of innocence. Then Diane drove home and spent 2 days in bed, demoralized by the turn of events. But William Wise's time would come. 2 mistrials. Oh my God. Diane beat herself up for her mistake. It was her responsibility. Monday at the office, Diane was with Van Buskirk, who said, quote, "I have a nickname for you, Ginzu Woman." Diane smiled. "Is that Japanese for stupid twit?" End quote. Nah. She had sliced and diced their expert witnesses into little pieces. After the mistrial, Leslie had spoken with jurors. 2 believed that Michelle may have killed her son, with Wise helping. They weren't sure he did it himself, and they had doubts about alcohol burning in spite of the expert testimony. Now, this was an opportunity. Diane knew she could remedy this. For now, though, she needed to focus on her other cases. Prosecuting isn't like it is on TV, where they're handling one case at a time. The discussions about Michelle Wise continued, as the defense had been able to introduce a sliver of doubt. Had she done it? Was she an accomplice? It was time to speak to Michelle. When Diane and Van Buskirk arrived, Michelle's mother expressed that they were uncomfortable with Michelle talking without legal representation. Diane asked if she had an attorney, with Mrs. Davis mentioning Voiles, with Diane reminding her that Jim Voiles had accused Michelle of murdering Matthew, and if Michelle had a lawyer, Diane couldn't speak with her. Gesturing them inside, Van Buskirk would lead the interview, since Michelle absolutely loathed Diane. And Leslie was direct. "Did you kill your baby?" Michelle firmly replied, "No." And then Leslie pressed, quote, "If this is the case, why did Voiles accuse you?" End quote. Stammering, Michelle struggled to respond. Van Buskirk asked her what she thought would happen with all the evidence against Bill. Michelle looked truly horrible and admitted she had been coached to, quote, "stretch the truth" at Voiles' insistence, end quote. Diane dismissed this, believing that William Wise was actually behind this. Leslie said that Michelle could be charged with murder since there were only 2 people in the house and her story had major inconsistencies. Quote, "Why didn't you save Matthew?" she pressed. Michelle pleaded, "I thought Bill would get him. I really thought that," end quote. She insisted that she cared for her son and that Bill would never hurt Matthew. Van Buskirk countered, quote, "He killed Matthew. Don't you see that?" End quote. Clearly, she did not. Diane felt frustrated, wanting to shake some sense into Michelle. And ultimately, they didn't get much more out of her psychological defense mechanism, denial, in play. Sigmund Freud first recognized it as, quote, refusing to accept reality or facts, allowing individuals to avoid anxiety and maintain emotional stability, end quote. Psychologist Dr. Clary Claney writes, denial can also lead to feelings of hopelessness or helplessness, as individuals may feel trapped by a situation they cannot change. This can further entrench the denial and make it harder to break free, end quote. During the interim between trials, Judge Barney retired for health reasons, and Diane was transferred to Criminal 5, where she wasn't thrilled with her new position. She soon faced high-profile case, Indiana versus Shane Allen, the son of the police chief charged with murder. Despite the chief's rigorous attempts to dismiss the case, he was unsuccessful. A meeting with him had left Diane feeling threatened. As jury selection approached, Diane was called into a livid prosecutor Scott Newman's office, where he was nasty and malicious, and Diane resigned on the spot, effective after the Allen trial. That shocked me. Now jobless, she launched into a redecorating project at home with Van Kirk beside herself. Diane Marger Moore had to try the Wise case. More twists and turns. Diane took a job at a large law firm handling fraud and arson claims for insurance companies. It really wasn't a good fit, though the seriously boosted salary was appealing. A month later, she received a letter from the prosecutor's office asking her to serve as special prosecutor for the William Wise case, a rare honor. Despite her husband having concerns about how she'd left her previous position, Diane accepted. Judge Jane Magnus Stinson, known for being fair and yet tough, would oversee the case. Diane would be working with the new chief arson prosecutor, Lisa Swain. Jim Voiles had left the case with dedicated defense attorney Mark Ernest, his replacement. Diane now reconnected with David Lepper and Dr. Pless, learning that Barker Davies had passed away, and this go-round, Steve Shand would need to get paid. With little funds, Diane thought they could do without Shand, but not without Jim Finneran. The test burn room was still being stored, but Diane opted to use video instead. In her absence, Van Buskirk found the firefighter whom Wise had dated, Margaret Jones, and she agreed to testify. Margaret had explained that Bill was a fire dispatcher when they met and seemed more interested in her job than in Margaret herself. When she asked if he had applied to the fire department, she revealed that he believed rescuing someone from a fire would get him noticed and hired. An unrealistic fantasy. I mean, could that be his motive? Rescue the baby, albeit too late for him to survive, and get hired by the fire department? Well, crazy, but that could be true. Van Buskirk also told Diane that after the publicity, she received a call from Michelle's cousin, an attorney with the Indiana Department of Insurance. At a family funeral, Bill had asked her if they could win $1 million verdict against the baby monitor company, mentioning that he had already spoken to an attorney. But cousin was horrified because this discussion was a month after Matthew had died. Oh my God. Well, Lisa Swain fended off motions from the defense, which sought to relitigate issues that had already been resolved by Judge Barney. The most contentious issue revolved around the inclusion of the baby monitor testimony. But finally, a new trial date again was set, March 2nd, 1998. Joining the defense team were Tom Leslie, a former arson prosecutor, and Jennifer Lukemeyer, who had worked with Voiles. The jury was selected smoothly, thank God, upping the alternatives to 3. In her opening statement, Diane maintained eye contact with the jurors, discussing the tragic death in 16 minutes while holding a photo of baby Matthew, the child neither parent had saved. In his opening statement, Tom Leslie portrayed Wise as a victim of a ruthless prosecutor determined to destroy his family. He said the fire was caused by a baby monitor, not the new father. The first witness, again, was Officer Keith Williams, who had previously worked as a fireman in Winston-Salem, North Carolina. Williams testified that he arrived at the flaming house determined to rescue the person trapped inside. A man in turnout gear stood by the open front door and said they had to find the baby. The man, William Wise, was not coughing and had no soot on him. Going in, they attempted to get to the nursery, but the heat and smoke were too intense. All of this taking seconds. Now covered in soot, William was coughing and smelling of smoke. During cross-examination, Tom Leslie pressed, insisting that Williams didn't know if William Wise had attempted to rescue Matthew before his arrival. Well, true, but also true. William Wise had no soot or smoke on him. In redirect, Diane pointed out that the front door was open, allowing air to intensify the fire, a fact that no one with fire training would fail to understand. Now, Indiana has an unusual law that permits jurors to ask witnesses questions. And I absolutely love this idea. A juror would write down the question, with the bailiff handing it over to the judge, who considers it. Lawyers were then permitted to ask questions based on the witness's response to the juror's questions. Now, a juror asked Officer Williams, quote, "Did you ever hear a baby crying?" End quote. He said he did not, as silence lingered in the courtroom. After being sworn in, Louis Bob Hyatt explained to the jury how the Metropolitan Emergency Communication Agency, or MECA, operated and discussed Bill Wise's responsibilities as a dispatcher, noting his probation status and his tendency to stretch the truth. A trained firefighter, he had worked with 2 Florida fire departments. Louis Bob pointed out the various ways that Wise could have contacted dispatchers directly to rescue his son, but failed to do so. He could have used the police radio found in his bedroom, but he did not. Before the jury, she pressed the radio's red button, quote, triggering an officer in distress alert, end quote, and getting an immediate response, which could have resulted in a legion of emergency personnel storming into the court. However, Louis Bob quickly responded that she was just testing the unit. She further explained how 911 calls were recorded, going over the 5:09 a.m. call Michelle made, followed by William Wise's call 27 seconds later at 5:10 a.m. Recognizing the dispatcher's voice, Wise greeted Jody and reported the fire, giving his address, chatted a bit, and then told her about the entrapment of the baby inside the house. So much for their motto, seconds saves lives. Defense attorney Mark Ernest played both 911 recordings to the jury. Diane asked if Louis Bob heard any coughing or stridor, something that happens to your voice when you inhale smoke. After an objection, the judge said to move on, but Diane's point was made. Lisa Swaim questioned newspaper delivery lady Cynthia Newedy, who confirmed that there was no fire at the Wise home before 5 a.m. that morning. Sworn in next, David Lepper described the decimated nursery, the search, and then finding the police radio. Lepper ruled out accidental causes of the fire, demonstrating it had not spread from inside the wall of the baby's room. He noted the smell of alcohol collecting the carpet sample. Wise's statements to Lepper revealed his extensive fire training, including knowledge of flammable liquids. Wise had told Lepper that the baby monitor under Matthew's crib was plugged into a wall outlet. Wise said that he settled on the couch with the receiver about 5 a.m., and returning from the bathroom, he peeked into Matthew's room, seeing no fire or smoke. When the alarm went off, he and Michelle went downstairs to shut it off. On returning upstairs, Wise turned on a light and, seeing the smoke, instructed Michelle to call 911 while he attempted to rescue Matthew. Wise says he made it about 2 feet into the nursery and that he threw a stool through the window so he could throw Matthew out the window. With the intense smoke and fire, Wise failed to get his son. Retreating, he realized he had not told Michelle to say that someone was trapped in the house, so he ran off to call 911 himself. Remember, all of that took 27 seconds. Both parents confirmed to Lepper that they had used alcohol in the nursery on Matthew's umbilical cord, which had fallen off weeks earlier. Diane asked if a trained firefighter like William Wise would understand that breaking a window and propping open the front door would feed the fire, with Lepper agreeing. Now an abbreviated burn room video was shown as a demonstration, not a replication. The blowtorch ignition stimulating the accidental fire start was not included. Lepper then explained terms like flashover and burn pattern to the jury, doing an amazing job. The cross-examination by Tom Leslie was tough, a deliberately confusing mess designed to rattle and confuse David Lepper, and it worked. Lepper became agitated as Tom Leslie switched topics rapidly. He went into great detail about Lepper's work history, then diagrams, then the carpet samples he had tested. He actually asked Lepper if he ruled out burglary as a cause, which was absolutely ridiculous. As Leslie flipped topics, Lepper became more agitated and tense. They went down a hypothetical rabbit hole on whether the bathroom fan had obscured the smoke in the baby's room, with Lepper concluding that it had not. Lepper regrouped and held his ground, saying, quote, "If an accelerant had not been used, it would have taken 45 to 50 minutes to burn to the length that I observed in that nursery," end quote. Shifting topics again, Leslie asked about the mattress. Lepper responded, but volunteered that most foam mattresses are made from petroleum products that can accelerate flames. Silently, Diane screamed in her head, "Stop volunteering information," gnawing on her lip. A barrage of questions ensued about electrical fuses, blow torches, arcing, foam mattresses, and isopropyl alcohol. At what temperature does alcohol burn? Lepper didn't know. Does it evaporate? Likely. What do people use it for? Leslie demanded. Lepper replied, quote, "Well, one thing it can be used for is to accelerate a fire," end quote. Oh, the questioning went on for a long time, wearing Lepper down. On redirect, Diane asked only a few questions, the last of which prompted Lepper to reaffirm that the outlet where the baby monitor was plugged in was not the source of the fire. There was nothing electrical in that room that could have caused it. The fire was intentionally set as a flammable liquid was poured and ignited. Overall, it was not the best day of the trial. Chemist Dirk Shaw from the Marion County Crime Lab took the stand. He examined the paint can containing a carpet sample and smelled isopropyl alcohol. This was scientifically confirmed using gas chromatography and mass spec. Leslie questioned whether the 30% water content in the rubbing alcohol inhibited burning. And Shaw said he had wondered about this too, experimenting, and found it burned easily. And in the end, there was no doubt that alcohol was in that carpet. EMT Doris Gilbert testified about assessing William Wise for possible injuries sustained at the fire scene. She explained that victims of fire and smoke exposure often have a hoarse voice and find it difficult to speak due to inhaling toxic fumes, gases, and heat, which causes a wheezing. The body's normal response is involuntary coughing as it attempts to expel these toxic fumes. Doris also mentioned that stridor, a high-pitched sound resulting from swollen or singed vocal cords, can make a person sound like a crowing rooster when breathing in. Yeah, you can't miss that. Her assessment process included examining nose hair, facial hair, mustache, and eyebrows. During exposure to hot smoke, gums may also appear very pale, and soot can cause the tongue to turn black. Would these be seen in someone who had been exposed to heat and smoke for, say, 2 or 3 minutes? Yes, Doris answered. On March 6, 1993, did she see William Wise? Yes, for approximately 15 minutes. And she had observed none of these symptoms in William Wise. Not one. Tom Leslie tried to challenge her testimony, but Doris held firm. The next witness was Amy Starati, an Indiana Department of Insurance attorney, and Michelle Wise is Amy's husband's cousin, who saw each other at family functions. About a month after Matthew's death, she spoke with the Wises at a family funeral, where she was horrified when he said they were suing Fisher-Price, hoping to rake in $1 million. She found it unseemly and disturbing. Kathy Roberts, a former colleague of Wise's at Mecca, testified about his engagement to Michelle and her pregnancy. She noted that Wise was unhappy about the pregnancy and wanted Michelle to have an abortion, which she refused. While he never mentioned that Matthew had been born, He complained loudly about not tolerating the baby's constant crying. Margaret Jones, the firefighter who briefly dated Wise, was also sworn in. Had Wise kept anything odd in his car? And Jones stated that he did. Volunteer fire gear was in his trunk from a town that was too far away for him to respond. Did Jones keep fire gear in her trunk? Well, she said she did not. Further, Wise told her that he thought he would drive by a fire, rush in and rescue someone, and be a hero, and that the fire department would give him a job as a firefighter. It was a fantasy, and he had never actually applied for a fire position. He seemed to believe that he could impress officials by being the hero at a fire scene. The cross-examination would suggest that either Jones was lying or Wise was foolish for his assumptions, which seems kind of pointless to me. So Jim Finneran, remember him? He's the forensic electrical engineer from Barker and Herbert Labs. He had been schmoozed into volunteering his testimony. Jim's job was to examine electrical products suspected of causing a fire. Providing photographs for the jury at each juncture, Finneran examined the inner walls, outer walls, sheetrock, studs, and outlets. There was no evidence of any electrical damage to the wiring in the box or in the nursery, concluding, quote, the wiring had nothing to do with this fire, end quote. They moved on to address the Fisher-Price 1510 baby monitor. Finneran produced the Baby Wise monitor receiver, and it worked perfectly. He then explained the step-down transformer, explaining how it reduced the amount of electricity down to the level of a 9-volt battery. After extensive testing, Finneran concluded the fire had not started due to the baby monitor. He also got out in front of a defense witness who was going to go on about the 9-volt battery and the steel wool. You remember that whole thing. Further, under oath with multiple demonstrations, Finneran stated, quote, in my opinion, the Fisher-Price 1510 deluxe baby monitor in baby Matthew's room could not have caused a fire, end quote. Period. Now, the book goes into greater detail and nuanced explanations of testimony and demonstrations, including a booming oops. So be sure to read the book. This part is really compelling. Now, the cross-examination left Tom Leslie red-faced and frustrated. I do admit to enjoying this part. Tamara Schneider was sworn in, a very athletic, middle-aged woman. She lived 2 doors down the same side of the street as the Wises, and there is a diagram on my blog at www.murdershelfbookclub.com, April 2025, so you can see it for yourself. On March 6, 1993, Tamara heard a pounding on her front door in a home with a very similar layout to the Wises. Jurors could now compare the time she took to answer the door with the times and the motions that Wise claimed to have made. She grabbed her robe, hurrying to the door as a man was yelling, "Help! My house is on fire." When Tamara opened the door, the man was gone, and she saw him running across her lawn, across the street to another house. Later, that same man returned to the burning house. During cross-examination, Tom Leslie questioned Tamara's employment history, which was really solid, and I have no idea what he accomplished with that. And that concluded trial for that day. Now, back in the conference room, the prosecution knew they had 2 days left. Typically stingy with praise, Diane told Lisa Swain that she would tell Scott how valuable Lisa had been during the trial, causing Lisa to beam with pride. Their next witness, Kathy Robinson, a Mecca employee, testified as the supervisor of William Wise. She described him as unenthusiastic about his wedding and his wife's pregnancy, mentioning that he called their baby Matthew an ugly baby. Wise complained about the baby's constant crying and disliked that his wife rushed off to attend him, ignoring Bill. During cross-examination, defense attorney Ernest flat out accused Kathy of lying. On redirect, Diane asked why Kathy remembered this conversation with Bill, and tearfully, Kathy revealed that she came to work the next day to learn that the baby had died, leaving her to question herself. Did I say something that caused that? And then it was Dr. John Pless, the Marion County medical examiner, was sworn in. Diane reviewed his impeccable education and defined a forensic pathologist for the jury. Asked about the difference between bodies in accidental fires versus accelerated fires, Dr. Pless explained that, quote, in an ordinary house fire, the body burns relative to its closeness to the flame. If it's in direct contact with the flame, the body is more severely burned. When the body is exposed to accelerants, the burning is more concentrated in one area than another. There may actually be portions of the body that are completely spared, end quote. And I'm thinking that tiny part of Matthew under the diaper that you could make out. And then they went there, the diaper absorbing the alcohol, acting like a wick. If the body is composed of a great deal of liquid in an accidental fire, it can take between 45 and 60 minutes to be consumed. Remember, this devastating fire took 16 minutes. Diane asked, quote, if a baby had been wearing a diaper and if an accelerant had been poured on that diaper, could he explain what you'd see at autopsy? End quote. Dr. Pless's description matched that of baby Matthew. Less burning on the body that was protected by the diaper, with other parts decimated. Dr. Pless described these injuries to the jurors, and it is the stuff of nightmares, with William Weiss at the defense table, unmoved, and the jury stunned. Diane asked, was an accelerant being poured on baby Matthew consistent with what he had seen? Yes, it was. The judge issued a warning to the jurors, and the photos were passed to them, their faces registering abject horror. Quote, was the destruction of baby Matthew's body, as illustrated in these photos, caused by a non-accelerated or accidental fire of only 16 minutes? No, he said conclusively. Now, I want to share with you that Diane Marger Moore gave me these photos, and calling them horrific does not do them justice. It is bad, murder bookies. It is really bad. And out of respect for Matthew Dean Wise, I am not posting them on my blog. I told you this is a really difficult case. Now, during cross-examination, Michael Ernest discussed the carbon monoxide poisoning that caused Matthew's death, while Pless explained the role of soot and toxic acids from the flames compromising one's respiration. It is very obvious in an autopsy. Ernest brought up the mattress again, suggesting that the chemical composition was an accelerant, with Dr. Pless agreeing. Ernest asked if urine could saturate a diaper, having a protective effect. It could, but it was not the cause of the extreme incineration of the baby. And I will spare you further details, but Diane and Dr. Pless reaffirm the use of an accelerant poured in the baby's diaper to start the fire. And the defense was up. And that's where I'm going to stop episode 119. We will return with part 3, second cast, episode 120, 27 seconds, on 16 minutes. Was the death of baby Matthew an accident or murder by Diane Marger Moore? The trial will continue with the defense presenting its case, defending William Wise on the death of his son, Matthew Dean Wise. Thank you for listening. I truly appreciate you joining me on this journey through some of the best true crime books. And if you enjoy the podcast, please share it and leave a 5-star review. You can contact me at jill@murdershelfbookclub.com or connect with me on X, Facebook, Instagram, and YouTube. Additionally, you can join my Patreon for $4 a month and help choose the next book I feature. Additionally, I've got some really interesting interviews coming up, so I will see you in 2 weeks, Murder Bookies. Written and produced by Jill, all rights reserved. Music, The Pewter Elephant by Blue Dot Sessions.